You do not yell at me. Ever. Do not yell at me. Ever.
Hold up.
No, you do not hold up.
I'm telling you,
Mr. Do not talk to me that way. Oh, we don't want to do that. We're done. We're done.
On February 14th, 2026, Lawrence Watkins appeared before Judge Simpson in a Michigan courtroom for a probation violation hearing that would test the limits of judicial patience and ultimately explode into one of the most volatile confrontations ever captured on camera. Watkins was on probation for felony charges and had been ordered to submit to regular drug testing as a condition of his supervised release. In mid-November 2025, he tested positive for cocaine, a clear violation of his probation that could result in immediate revocation and prison time. But Watkins had an explanation that defied both logic and basic chemistry. He claimed he had found cocaine in an old jacket pocket, touched it briefly to examine it, and immediately flushed it down the toilet without using it. According to Watkins, the cocaine somehow entered his system through his skin during this brief contact, resulting in the positive test. His attorney hoped to show that Watkins' THC metabolite levels had been progressively declining over multiple tests, suggesting he had stopped using marijuana as ordered, and that perhaps the cocaine levels might show a similar pattern of decline. But when Judge Simpson reviewed the actual test results, what he saw told a very different story, one that made Watkins' claims of innocence not just implausible, but scientifically impossible. And when the judge confronted Watkins with the evidence, what should have been a moment of accountability would instead become an explosion of defiance, disrespect, and consequences that Watkins never saw coming.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me
I'm not lying to you, Mr. Simpson.
Oh, we don't want to do that. We're done. We're done.
Do not smoke weed, baby.
We're done.
I'm never.
We're done.
Simpson, I'm not lying to you.
You do not yell at me. Ever.
I'm not lying.
Do not yell at me. Ever.
Court calls the case. People versus Lawrence Watkins.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watkins, who's present. Judge, state your name, Mr.
Lawrence Watkins.
Your Honor, at this time, I believe Mr. Watkins will be waiving his preliminary examination.
Before we do that, we have a violation report. You can see that.
Yes, Your Honor, I did see the report.
Mr. Allen.
Your Honor, I received the report yesterday. I haven't seen any of the underlying tests. It's my understanding that there was a positive test for cocaine several weeks or in mid-November, if my recollection serves me right. He was counsel for that. It was he has not had any other positive tests since. There has been multiple tests. Your Honor has the report.
I do.
Your Honor, Mr. Watkins reports that he has not used cocaine. He has not used marijuana since being ordered not to, and those. Right. That's why I was hoping to.
Hold on, before he says that, if you want me to call over and get the amount.
Well, that's what I was wondering, Judge, if the lab amounts were going, if the amounts were going down progressively with each test, that would be indicative of.
Can I speak, Simpson?
You can if you want to, but you might want to let your attorney talk to you.
No, I don't mind speaking at all. I mean, as far as the marijuana, Mr. Simpson, like I said, since the day I've been going over there, I haven't smoked weed since. And I have no reason to lie to you. Why would I lie to you? I can just tell you the truth. I would just tell you, yes, I smoke, but I haven't smoked marijuana since. As far as the cocaine, like I told my attorney, I was going through my old clothes. Like I wouldn't lie to you. I would have no reason to lie to you at all. I'm doing great in my life. I'm doing everything I'm supposed to be doing. I showed up to court. You didn't have to put a warrant out for me.
Can you order the results of the marijuana? I need levels.
Yeah, please. I haven't smoked at all, period, Mr. Simpson. If I did, I would tell you. I have no reason to lie to you. And I can just simply say, yeah, I smoked, I slipped up here and there, but I never have. I never smoked since the day I've been through the report, not one time. Not one time have I smoked, period. Not once.
So what's up with the cocaine?
I told you, like I was going through my clothes. I can talk, I don't mind talking. And I found some cocaine in my pocket. The only thing I did was took it out of my pocket, Mr. Simpson. That's all I did. And took it straight to I could have sold it. I could have did a whole lot of stuff with it. But I told you I'm doing so good in my life right now. I took it straight to the toilet stool, and flushed it. I have no reason to lie, Mr.
So
Simpson.
why is it showing up in your system?
I don't know. I just touched it, Mr. Simpson. I never used cocaine in my life, ever. Just touching it.
You know,
Mr. Simpson, I would never.
no, listen. I've been doing this for a minute. I can't believe you're like an amoeba. What, are you absorbing it through your skin like
Yes,
that?
Mr. Simpson.
Oh, okay.
Mr. Simpson, I promise you.
Give me the levels on the cocaine too, please.
Yeah, please, Mr. Simpson, I wouldn't lie to you. I have no.
Okay.
Why would I
So
lie to you?
here's what I'm, yes. Ms.
The
Lundy.
levels for the cocaine were actually included in the original report the court has. It's pretty small print. It does say up
Oh, I see it. They put it in there.
and it was confirmed.
And I sent that to the. I had.
So
Go ahead, Mr. Simpson.
I don't know how you get 152 milliliters. How do you do that?
Can I talk, Mr. Simpson?
I would.
Well, you've been talking.
No, listen, please. Let me clear this up to you. There's no.
You're not
way-
doing a very good job.
Mr. Simpson. I know you want him to talk, but let me talk, please.
No, I'll let anybody talk that wants to talk to me. I'm just telling you, you are not helping yourself.
I know. I don't see how, since I would never lie to you, ever. I've never used cocaine in my life. Only thing I did was touch it. Ms. Willard was right there when I showed her, and I took it straight to the. I don't know if it stayed in my system when I flushed it or whatever. But I could take a lot of tests. I've never used cocaine in my life, Mr. Simpson.
How does it stay in your system when it didn't get there?
When it didn't get there.
You took cocaine out of some old clothes,
Right.
took it right from there to the bathroom.
I didn't say old cloud out of a jacket I had that was in storage, Mr. Simpson. I would
Okay, and then I know you would never lie to me.
never. Okay.
And so then you didn't do anything with that cocaine.
Mr. Simpson, I
And
never.
then somehow or another that gets into your system
Yeah.
at these levels.
Mr. Simpson.
Oh, you've
Yeah.
got to be kidding.
Okay, listen.
Tell you what we're going to do. I'm going to wait for the levels to come across. In the interim, Mr. Allen, take him back, put him in, and then we'll bring you back out.
Right.
And then I'll do that.
Okay,
I'd let you talk.
I know. Can I just say one more thing?
Sure.
Listen, Mr. Simpson, this is what I'm trying to tell you. I call every week and go drop, right? If I'm using cocaine, there's no way in the world I would have went over there and dropped. I would have came in. I would have called over there, told him something, and missed the whole thing, Mr. Simpson. I would have missed it. I would have made.
Watkins launched into his defense with remarkable confidence, insisting repeatedly that he had no reason to lie to Judge Simpson. He swore he hadn't smoked marijuana since beginning probation and claimed his cocaine positive resulted from merely touching the drug when he discovered it in storage. His story: he found cocaine in an old jacket pocket, examined it, and immediately disposed of it by flushing it down the toilet rather than selling it or using it. When Judge Simpson asked the obvious question, "So why is it showing up in your system?" Watkins responded that he had simply touched it and had never used cocaine in his entire life. The judge's response cut through the absurdity. "I've been doing this for a minute. You're absorbing it through your skin like an amoeba?" This sarcastic question exposed the fundamental impossibility of Watkins's claim. Cocaine cannot be absorbed through casual skin contact in quantities sufficient to produce a positive drug test with quantifiable levels. The judge ordered detailed information on both the marijuana and cocaine test levels, and what those results revealed would seal Watkins' fate. The cocaine test showed a concentration of 152 nanograms per milliliter, a level that could only result from actual ingestion, inhalation, or injection of the drug, not from briefly touching it. The marijuana metabolite levels told an equally damning story. They had been declining progressively from October 29th through early December, dropping to near zero, which suggested Watkins had indeed stopped using marijuana. But then, on December 17th, the THC levels suddenly spiked back up again, indicating recent marijuana use despite all of Watkins's passionate denials. Judge Simpson recognized what was happening. Watkins had been clean for a period, likely due to fear of consequences, but had relapsed into drug use and was now lying about it while swearing on his life that he was telling the truth. Watkins attempted one final argument to prove his innocence. If he had really been using cocaine, why would he have voluntarily shown up for drug testing instead of making excuses, claiming illness, or simply skipping the appointment? This logic had superficial appeal. Why would a guilty person walk into a trap? But Judge Simpson understood what Watkins apparently did not. People who use drugs while on probation often convince themselves they can beat the test, or they use sporadically and hope the drugs will be out of their system by test time, or they simply lack the judgment to avoid risky behavior. Watkins' willingness to take the test didn't prove innocence. It proved poor decision-making and overconfidence. Every word Watkins spoke, every passionate denial, every claim that he would never lie to the judge was building toward a confrontation that would change the entire trajectory of the hearing.
Hospital. Or I could have said this. Oh, somebody put some cocaine in the weed, and I accidentally smoked. And it was in the weed. I could have told you all of that. But I'm telling you the honest to God truth, Mr. Simpson. The honest to God truth. I did not smoke no weed, and if I did that, I could have told you that. You're a fair guy. You've been fair with me every time I came in here. Every time I ever came and seen you always been fair with me. So I wouldn't stand in front of you and lie to you. And if I did use cocaine, I would ask for help. I've been doing good for 18 months, period. Working every day, taking care of Miss Will's grandmother for 10 months straight. I never lied to you, Mr. Simpson. I wouldn't do that when I know I can ask you for help.
Okay. I'm going to get levels and then deal with your case at some other point. But right now you're going to go with my bailiff. We'll get that information and then we'll bring you back out.
Today?
Yeah.
Okay, Mr. Simpson.
Unless you want me to.
No, I don't.
Okay,
I really
but if
don't.
you keep talking, it's going to be tomorrow.
All right, thank you.
Okay, stop talking. Good, there we go.
I wouldn't lie to you.
Okay, I know you wouldn't lie to me.
Court does call the case of the people of the state of Michigan versus Lawrence Watkins.
Ashley Lonnie for the people.
Mike Gaddy, Assistant Public Defender on behalf of the defendant, Your Honor, who's standing here on my right. State your name.
Lawrence Watkins.
All right. Couple of things. First of all, we have sent to counsel the levels.
Yes, Your Honor, I did receive I did receive them both by email and a printout, and I have shown them to Mr. Watkins. I would. They do. This is for THC. I'm assuming it's for the metabolite, not active. They do show that they are progressively going down, and then they. Well, this document speaks for itself. Obviously, there is a slight jump from 1210 to 1217 of about.
Slight?
Well, I mean.
Okay.
Well, when we look at
to where it was, yeah.
Yeah, and I mean it's 28. I think the bar graph is probably it starts at 60. I mean, if it started at 0, 1210 and 1217. 1210 would be about 2/3 the size of 1217, not 1/10. So, but it does. I don't know if certain things. Obviously, our body metabolizes things at a different rate. There's a significant reduction in the late month of in late November, and I don't know if these metabolite levels can go up with things like hydration or just how active we've been in the way our body's metabolizing. I do know that since October 29th, even in the worst case scenario, these levels have gone down well over 100, looks like over 130 points. I'd ask the court to, if the court's concerned about this,
He needs to just tell
test.
me, and I don't mean to interrupt you, Mr. Getty, but he needs to just tell me the truth. I mean, that, we can sit there and play this game, but the cold-hearted reality of what happened is he almost goes down to a 0 after it kind of falls off, and then all of a sudden it just shoots back up. Then he's trying to tell me that on the 19th of November, that all of a sudden this cocaine through some osmosis process, I don't know how that all of a sudden just gets into his system. So he's just got to start being honest and don't sit up there and say, I wouldn't lie to you, Mr. Simpson, because this tells me you did.
Mr. Simpson, I would take a lie detector test for you. I would go over there 3 days.
Done.
Okay.
Your Honor, I'd ask the court to, it looks like he's been testing every 7 to 8 days, maybe increase it to 2 or 3 times a week to allow him to demonstrate that these levels will continue to go down and that there will be no further cocaine tests. Maybe bring us back in 2 weeks, revisit this issue on a adjourned PC, see if the court's inclined to do that. This was going to be a waiver today, but I can understand the court's concern.
When court reconvened after the drug test levels were obtained and reviewed, Watkins's attorney attempted damage control by pointing out that the THC metabolite levels had indeed been declining overall, with only a slight jump from December 10th to December 17th that might be explained by variations in metabolism, hydration levels, or other physiological factors. The attorney suggested increased testing frequency, 2 or 3 times per week instead of weekly, to allow Watkins to demonstrate that levels would continue declining and that there would be no further cocaine positives. This was a reasonable legal strategy. Give the defendant a short leash, monitor him closely, and see if the evidence supports his claims of sobriety or exposes continued drug use. But the attorney's argument overlooked the fundamental problem Judge Simpson had already identified. The judge laid it out plainly. Watkins' THC levels had dropped nearly to 0 after a steady decline, suggesting he had stopped using marijuana. But then the levels just shoots back up on December 17th, contradicting Watkins' claims of complete sobriety. More critically, Watkins was trying to convince the court that on November 19th, cocaine somehow or another gets into his system at measurable levels through mere skin contact, a claim the judge found preposterous. Judge Simpson's frustration was evident. He's just got to start being honest and don't sit up there and say, I wouldn't lie to you, Mr. Simpson, because this tells me you did. The evidence of deception was literally on paper in black and white, quantified in nanograms per milliliter, scientifically verified through confirmation testing. Watkins could swear his innocence 1,000 times, but the chemical analysis didn't lie. The attorney's request for a 1-week adjournment with continued testing was a final attempt to give Watkins an opportunity to prove himself, but Judge Simpson had already made a decision that signaled how seriously he viewed Watkins's violation and dishonesty. He revoked Watkins's bond and remanded him to custody immediately. This meant Watkins would sit in jail for the next week while awaiting the next hearing, rather than remaining free in the community. Bond revocation is a significant judicial action that reflects a judge's determination that a defendant poses a risk of flight or danger to the community, or that continued release would undermine respect for the law. By revoking bond, Judge Simpson was sending a clear message. Lying to the court has immediate consequences. What happened next would show just how badly Watkins had misread the situation.
I'm going to adjourn him out 1 week to the 26th, 2024. 9 a.m. This time, based upon what the court sees, defendant's bond is revoked, he's remanded.
Your Honor, if I could say, one other thing is that he's been working steady for the last 18 months. He is a caregiver for his significant other's mother. His life is a much markedly different thing now than it was even in October. This is a...
Well, he needs to tell me the truth.
Hold up, Mr.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me.
I'm not lying to you, Mr. Simpson.
Oh, we don't want to do that. We're done. We're done.
Did I smoke weed, baby?
We're done.
I never.
We're done.
Listen, I'm not lying to you.
You do not yell at me.
I'm not lying.
Do not yell at me ever.
Hold up.
No, you do not hold up.
I'm telling you the truth, Mr.
Do not talk to me that way. You do not talk to me that way.
I'm not talking
ever.
to be disrespectful.
Ever.
But I came in here when I was full of garbage. You worked with me. Now I'm telling you the truth, and you telling me I'm lying to you? I have no reason to lie to you, and I know I can tell you the truth. When I used to come in here and I had nothing to stand on, you gave me every chance in the world, Mr. Simpson.
I did. That's why I
can't believe it.
Why I expect the truth from you.
That's what
I'm looking at the graphs.
Even when I came here, I was full of garbage. Simpson, you let me go. I'm telling you the truth now, and you think I'm lying to you? I'm taking care of her grandmom. I've been doing this for 10 months straight. I've been working. I'm paying child support. I got my name on the lease on the house. I never came in front of you and I had these things accomplished. Now you think I would lie to you? When I know that you're a man and let me finish talking, please. I didn't mean to yell at you, Mr. Simpson. I got the utmost respect for you, and I always have. I'm sorry. But I wouldn't lie to you, Mr. Simpson. I promise you, I'm so sorry for raising my voice. But I wouldn't lie to you when I know I can tell you the truth.
Don't ever do that to me.
I'm sorry, Mr. Simpson.
Shut up right now.
The moment Judge Simpson announced that Watkins' bond was revoked and he was being remanded to custody, Watkins' composure shattered completely. His attorney attempted to make one final plea, noting that Watkins had been working steadily for 18 months and was serving as a caregiver for his girlfriend's mother, but Watkins cut him off mid-sentence. "Hold up," Watkins shouted, interrupting both his own attorney and the judge. Judge Simpson's response was immediate and sharp. "No, you hold up. Don't tell me to hold up." But Watkins couldn't stop himself. "I'm not lying to you," he yelled, his voice rising in desperation and anger. The judge warned him firmly, "We don't want to do that. We're done. We're done." Watkins ignored the warning entirely and kept shouting, "I ain't never smoked weed." The judge's voice cut through the courtroom. "We're done." But Watkins continued yelling, and Judge Simpson delivered the line that should have stopped any defendant in their tracks. "You do not yell at me, can't yell at me ever." The use of ever wasn't rhetorical emphasis. It was a judge asserting the absolute authority of the court and warning that crossing this line would result in consequences beyond simple bond revocation. Under Michigan law, specifically MCL 600.1701, judges have the inherent power to hold individuals in contempt of court for behavior that disrupts proceedings or shows disrespect for the court's authority. Criminal contempt can result in fines and jail time separate from and in addition to any underlying criminal charges. Watkins had just crossed that line. His decision to yell at Judge Simpson, to interrupt the court repeatedly, and to continue arguing after being told the hearing was over constituted direct criminal contempt, contemptuous behavior committed in the presence of the court that interferes with judicial proceedings. The judge could have immediately held Watkins in contempt and imposed additional jail time on the spot, but Watkins wasn't done digging his hole deeper. He launched into an emotional speech about how he had come before Judge Simpson in the past full of garbage, and the judge had given him chances, about how he was now telling the truth and couldn't believe the judge thought he was lying, about how he was taking care of his girlfriend's grandmother and had accomplished so much. Judge Simpson tried to cut him off, but Watkins kept talking, his voice rising with emotion and frustration. Finally, realizing he had raised his voice and interrupted the judge, Watkins attempted to apologize. "I didn't mean to yell at you, Mr. Simpson. I got the utmost respect for you and I always have. I'm sorry." But the damage was done, and Judge Simpson's response left no room for misunderstanding. "Don't ever do that to me." Watkins tried to apologize again. "I'm sorry, Mr. Simpson." The judge's next words were delivered with absolute finality. "Shut up right now." When Watkins attempted one more apology, Judge Simpson cut him off. "Shut up and turn around. Just shut up." What Watkins had failed to grasp in his emotional state was that his outburst had transformed his situation from bad to catastrophic, and Judge Simpson was no longer in the mood for mercy or second chances.
You don't ever do that to me. Shut up.
I can't believe you doing
And I know my mom taught me better than that, but you better shut up.
I can't believe you
Shut up and turn around. Just shut up. I sat up there and I listened to you. I did all of that. I don't believe your story about the cocaine. What I was serious, do not say another word, because if you say another word, you're gone. I'm done. I went over and I said I was hoping that the graphs would come back and they would indicate to me that you had not used THC. I was hoping there was something in your story.
Man, I ain't lying to you. Hey, babe, what's the phone number? I'm sorry, just take me to jail. Babe, what's the phone number?
Go.
What's your phone number, babe?
Just go.
I'm lying to you. Just take me down, man. I am not lying to you, man.
After Watkins was removed from the courtroom, his girlfriend Amanda Willard made an emotional appeal to Judge Simpson. Willard, a recovering heroin addict sober for 6 years, explained that Watkins had completely turned his life around and was now her sole help in caring for her 84-year-old grandmother with Alzheimer's. She pleaded that without him, she had no one to watch her grandmother while she worked. Judge Simpson revealed he personally knew Willard's grandmother and family, which created an unexpected connection. Against what appeared to be his better judgment, the judge set bond at $5,000 with a 10% payment option, but made absolutely clear this was mercy based on trust in Willard, not Watkins. He warned that if Watkins came before him again, yelling or being disrespectful, the bond would be revoked immediately. The case was continued to the following month. Under Michigan law MCL 771.4, when probation is violated, the court can continue probation with modified conditions, extend the probation period, or revoke probation entirely and impose the original sentence. Watkins was facing potential years in state prison if his underlying conviction was for a felony drug offense. The cocaine-positive marijuana relapse lies to the court, and his outburst yelling at the judge created a strong case for complete revocation. His behavior could also trigger contempt of court charges under MCL 600.1701, adding up to 93 days in jail and fines. The only thing preventing immediate revocation was Willard's intervention. Whether Watkins would heed this final warning or squander his last chance and end up in prison for violations that could have been avoided through honesty and respect remained to be seen. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.